SJC-11534, Commonwealth v. Harold Fay.
No.
Yes, counsel. Good morning.
Good morning, Your Honor. May it please the Court. I'm John Fennell, and I represent Harold Fay. Here, the judge erroneously admitted evidence that Fay confined the victim in his 1995 Athol offense.
Why isn't that, even if it was error, non-prejudicial? Because, the other three incidents to which the defendant pled also established certain of the factual predicates that the judge found.
It's prejudicial because the other three offenses did not include confining. They only included the luring, approaching, and targeting of children. And comparing those offenses to the offense in Garassi, which was a case where a man followed two female children down a hallway, and he was convicted of assault, and that was overturned as being insufficient evidence for an assault. And what this court did in Suave was to import the standard for an assault as the objective standard for whether a victim reasonably apprehends a contact sexual offense.
But Suave makes a specific reference to the fact that these were not child victims in that case.
They were not child victims in Garassi?
In Suave.
Well,
I mean, in setting the standard.
That's right, Your Honor. The court laid out a series of factors to consider, and one of them is the targeting of children. That's just one factor, and that's something that was going on in Garassi. He was following children down a hallway and talking to them for about 300 feet. That was a targeting of children incident. And this targeting of children, the Commonwealth in their brief discusses the heightened concerns for children, and that those are understood. But when we're looking at whether the evidence is sufficient for an assault, it's an objective standard after Suave, that's what it said, and there just isn't the objective evidence here on the three offenses.
Is confinement so important to you because it would be, in thinking about what would be, from the child victim's standpoint, reasonable apprehension of a sexual contact offense, which is the Suave standard. In establishing that, the luring and the attracting and so on and so forth might not be behavior that would be enough to sort of establish that a child victim reasonably feared physical contact. But if confinement were added into the picture, confinement might be enough to have a child victim reasonably fear physical contact offense?
I think something along those lines is right, because with confining is can't leave. And in the other offenses here, particularly the 1999 Westfield offense, the victim was in the truck with Mr. Fay and then got out of the truck and came back to the truck. Mm-hmm. So there's this element of being able to leave. And when someone's confined, they can't leave because of some kind of threat.
Well, is that also the contact? Does that satisfy the element of contact? Touching, the confinement?
Well, that's before. This is before my due process argument, where I say that a likely future contact offense is required to comport with due process. So before getting to the due process argument, I think that under the Suave rule, which comes before that, confining could be the line here, because with confining, the child can't leave without some kind of contact occurring, that the child is afraid to leave and thinks there'll be some kind of contact happening if the child does try to leave.
Now, where there is a child, do you agree that the reasonableness should be through the eyes of a reasonable child as opposed to a reasonable adult?
I think under Suave, we have to be careful of moving from a objectively reasonable adult to a child, because children are kind of all over the place in what they think is happening and what is going on. So there certainly needs to be some check from going to what an objectively reasonable adult would think to what a child would think.
So your answer is no, it should not be a reasonable child, but a reasonable adult at all times?
I'm not sure what a reasonable child would be, but there needs to be much closer to a reasonable, objectively reasonable adult.
Because you had substantial trauma, I gather, in this case, was there not, from the incident in the truck? I mean, 2 years later, the person is still appeared traumatized by it?
That's what the mother said, yes, and here establishing that children get upset for lots of reasons, and retroactively we try to find a cause for that, and it's very difficult, and that's too loose of a standard, I think.
Well, except that if the stimulating event to the child's traumatic response to something is what is at least ostensibly, or can be shown to be ostensibly, sexual predatory conduct, isn't the nexus established?
Well, Your Honor, I think here, my recollection of the record is that this doesn't happen until a year later. She's discussing what happened with her mother, and then the difficulties occur in her emotional difficulties.
Is the trauma the same thing as the shock or alarm that establishes the crime?
I think they are separate things. What is shocking and alarming might not cause trauma until later, or maybe the trauma that occurs isn't because of the shock and alarm, but what is realized at a later date was actually going on and why this was a significant event. So the shock and alarm for the crime of open and gross lewdness is distinct from any trauma that could occur. Moving on to the due process argument, which is that it's a violation of substantive due process to commit someone as a sexually dangerous person without expert evidence or here a finding by the judge that contact offenses are likely in the future. So here we're in a better position because the judge explicitly found that based on the testimony, the only likely future offenses were non-contact offenses. So contact sexual offenses are not likely. In light of this finding, objectively, a future victim cannot reasonably fear a contact sexual offense.
Why is that logically so? Because, I mean, the fact that you could be, the judge may have found no more than that, Mr. Fay is not likely to do anything other than he's done in the past, which were open and gross lewdness convictions, which didn't involve sexual contact, but might have given rise to a reasonable apprehension on the part of the children that there would be physical contact. And you're basically saying that alone can never be enough because
Right.
that doesn't establish dangerousness?
Yes, because these cases require expert testimony on two factors, on some kind of mental condition and then future dangerousness. And expert testimony is always required for the future dangerousness. No amount of victim testimony could establish that. And so the expert testimony, and here are the findings, the best evidence that we have of what's going to happen in the future. and anyone objectively looking at the situation would want that expert testimony or hear the findings of the judge. And to go against that is irrational and is a violation of substantive due process.
Well, following up on what Justice Lenk said, so you would agree that this finding essentially says, well, he's likely to commit the same crimes in the future that he's committed in the past, which are non-contact crimes.
Yes.
Okay. What about, are those crimes likely to put children in fear of sexual assault?
No,
Why not?
because in
Sure did here.
Pardon?
Sure did here.
It did not put them in fear of a sexual assault. They all could leave. They all
Got away. Yeah.
well, just simply walked away. In several of the offenses, he was just sitting there and asked them to get him cigarettes, and they didn't do that. They didn't go any closer to them. The one sitting in the truck, she got out of the truck and then went back to the truck. And all these other ones, and all of them, they simply left.
But what, I mean, I guess maybe it's a semantic question I'm asking, but it seems to me one can be in reasonable fear of a sexual assault, and as a consequence of that, one leaves. I mean, those are not mutually exclusive, leaving and being in reasonable fear or apprehension of a sexual assault, are they?
Well, Your Honor, I think there we're getting into how high the threshold would have to be for confining someone under the sexually dangerous person statute. In our lives, we make lots of decisions because of things that we fear. Someone might not want to fly on an airplane because they fear the airplane will crash. But if you look at the best evidence we have, the statistical evidence, airline travel is the safest way to travel. And we're entitled not to get on airplanes, to drive wherever we want to go, all those kinds of things. But when we get to a level of how we're going to, in switching over now to someone who is free to leave and does leave because they don't like what someone's doing, because they don't like what they perceive as disgusting, they leave. And it's not dangerous.
But it's caused them, I mean, arguably or theoretically, if it has caused them significant traumatic emotional injury, is that not something we can take into account in terms of dangerousness?
Well, we don't have any finding about traumatic injury here and where it came from, so we need something like that. I think that it is important that physical injury certainly is too high a threshold. That's right. There are plenty of contact sexual offenses that don't cause physical injury, and someone can be held as a sexually dangerous person because they're likely to commit those crimes. But then going over into trauma and trying to talk about trauma and where it came from, we'd at least have to have some kind of proceeding to establish that this trauma occurred from it, and that wasn't it's the kind of trauma that we can expect from the offenses that occur, and we just have nothing like that here. We have this account, and there are no findings about that. There's
Well, he's trying to get close to 8-year-olds, 9-year-olds, 10-year-olds, 11-year-olds, and 14-year-olds, girls and boys, right?
That's
Wants to
right.
get close to them.
Yes.
So that he can shock and alarm them and make them pretty damn scared. You don't think?
shock and alarm. That's
Scared.
yeah, and that's
And they ran and they got away. They left.
they left.
Right. So what do they fear? Fear him, fear what these are children. Fear
And-
what he might do to them?
And it's something disgusting.
That reasonable?
It's reasonable to leave the presence of things that are disgusting. And we can leave things that are disgusting without those things being dangerous. And that's really the problem if we move away from the requirement of future contact offenses, is that we're going
Have efforts by this gentleman to put himself in contact as close as possible by following, stalking, luring them to get close to him. Right?
He got close, there was no contact, and the fact that he was so close and did not cross the line to contact shows control. And something here that there's pedophilia here. The judge found that Mr. Fay has a diagnosis of pedophilia, And it's important to notice, and this is in the record, the Diagnostic and Statistical Manual definition for pedophilia. A man can be diagnosed with pedophilia on the basis of thoughts and feelings alone without ever committing a contact sexual offense.
But you, at least as I am understanding your argument, you draw zero distinction between children and adult victims. Is that true in terms of your constitutional argument?
In terms of the constitutional argument, I don't draw a distinction because once we cross over the line in the constitutional argument to non-contact offenses, it just becomes too wide open for what people can be committed for. It's not anything that has the standards required to comport with substantive due process, and that's the problem in this
All right,
case.
thank you,
Thank you,
Counsel.
Your Honor.
Good morning, Your Honors. Catherine Robertson on behalf of the Commonwealth. And the Commonwealth is respectfully requesting that the court affirm the trial judge's decision in this case that at the time of trial, Mr. Fay was a sexually dangerous person. This case was tried and decided after the court's decision in Suave. So Judge Roop had the benefit of the court's view of what the statute required.
Let me ask you, in terms of the findings that the judge made and the evidence that she heard, was there any evidence that any of the children had said that they were afraid he was going to hurt them?
I don't believe there's any evidence articulated in precisely those terms, Your Honor. There is expert testimony from Dr. Ruth Weir that the children, because of their age and their sensitivity, that she believed that they would reasonably and objectively fear a sexual contact crime. And she drew a distinction between people who were, she was asked on redirect examination, and this is in the transcript in the second volume, I could tell you the pages if I had a minute or two, but that she drew a distinction between children who were under 18, and she said her opinion might change about whether or not Mr. Suave was sexually dangerous if his victims were 18. She said it's under the age of 18 that this very intrusive and predatory conduct and these acts of approaching and luring victims and getting very close to children and talking to them explicitly about sexual matters, and that would cause a child, reasonably and objectively cause a child to fear a contact sexual crime. So she had...
And what does she base that on?
Well, she's a trained
this is
psychologist.
is it untethered to, statistical studies or
Yeah, there's no indication, I don't believe, Your Honor, that there was any indication that she tied that to any statistical study.
Which is why I ask, apart from the opinion that, children as a whole,
Right.
Would be, whether or not there was anything to suggest that that the conduct in which it was clear he had engaged
Yeah.
and was convicted of open and gross offenses.
She did not.
As to any of those children, I mean, there was the luring, the attracting, in one instance, arguably the confining, and so forth. But is there, none of those children were in fact physically touched.
None of those children were that's correct.
And so, I couldn't quite grasp from that whether or not any of that behavior was such that the children would be, or thought, even indicated that they were fearful of being touched.
The best that the most that you could find on this record, Your Honor, I think, is the what the victim volunteered, the granddaughter volunteered, the 11-year-old granddaughter volunteered a year later when she disclosed to her mother what had happened in the truck. And at that point, a year after the events in question, she was hysterical. She was frightened. Her mother had to assure her that she would never see her grandfather again. So there is a degree of trauma a whole year after the events in question. She couldn't bear not to tell her mother. She perhaps felt guilty that she had some responsibility. Dr. Ruth Weir didn't say there is any study out there that says that this kind of intrusive and predatory approaching and luring will have an impact on a child psychologically, that's different from the impact that it might have on an adult psychologically. But she is a trained psychologist, and that was testimony that she offered in front of Judge Roop, and it's noted in Judge Roop's findings. I can tell you that I looked to see whether there was I tried to see whether there was any literature on this topic in preparation, in preparation of the brief, and I was not able to find any. I don't know that any exists. I guess I would say one other thing, and that is that we do, I don't think we question that if there is touching, that there is a psychological impact on a child or perhaps even an adult victim. There isn't physical injury in those cases either. The injury that we're talking about, at least in some cases of indecent assault and battery on a child under 14, is not a physical injury. It is the emotional trauma of being touched inappropriately, being introduced inappropriately to a sexual activity or matter. And so I'm not, to draw that kind of line between a contact and a non-contact offense, where in this case you have again, the word, I guess this is a word that not the qualified examiner, but the probable cause examiner used, was intrusive. Dr. Bell used the word predatory. So, and that again was based on this luring and approaching behavior that the court identified in Suave, and I think identified because those are factors that would increase the victim's apprehension of what was going to happen next. So, and again, these are children. I think to Justice Gantz's question to my brother, I do think you would have to look at this from a reasonable child standpoint. I think there's a substantial body of law, state law and federal law, that says that we have a compelling interest in protecting children, and that we view child victims and protecting children from exposure to sexually explicit, material, but even activity. This is sexually explicit activity in real life, that the government has a compelling interest in protecting children from having that happen to them. With respect, I guess, unless there are further questions,
I've got one.
Sure.
Do you agree that in cases where there is no likelihood of a contact offense, that in order for the Commonwealth to prevail, one of the QEs would have to testify that there's a likelihood of non-contact offenses that would meet the SWAV standard?
I think that the judge would have to be able to make a finding that the child victim would reasonably and objectively fear.
Okay, but that's not my question.
I'll try to answer your question.
You know that if there is no evidence of
Contact.
no evidence of likelihood from a QE,
Yes.
that you can't win even if the judge were to find likelihood.
Okay.
And I'm asking whether that same standard is here, is that if a QE finds there's no likelihood of a sexual, of a contact offense, can the case survive if the QE does not go on to say, I do find a likelihood of non-contact, which would meet the SWAV standard?
I think that question may go to the difference between the sort of the terminology that's used by a psychologist and the legal standards that are set by this court. And so it's hard for me to answer in the abstract. In this case, we had the QE
Right,
saying.
I understand. Here you had
So
it.
I have it. Whether, it's a little hard, I don't know what the facts, I don't know what the facts would be that would give rise to a situation where, I think the Commonwealth should be trying these cases in such a way that the qualified examiners are addressing this question after Suave. And in fact, in this case, because it was tried after Suave, but very shortly after Suave came down, the Commonwealth asked the qualified examiners, who had both come back and said, we believe he's sexually dangerous, they asked them to reassess their opinion in light of Suave, and to say at this point, in view of what the court has said in Suave, do you still believe that this man, Harold Fay, is a sexually dangerous person? And in both cases, Dr. Bell and Dr. Rousseau each came back and said, yes, I still believe that Mr. Fay is sexually dangerous. I do believe that it's incumbent on the Commonwealth to try a sexually dangerous person case where there is no history of a contact offense in light of this court's opinion in Suave.
But, and from what you just said, at least, it may have been belt and suspenders, but you would acknowledge that better practice may be to do just what you did or your office did. That is, before the case has even been tried, the QE is in the examination. In order to get it to a trial, I think that's Justice Gantz's question, in order to get over the Johnstone problem that you have at least one of those QEs saying this meets the Suave standard.
I think that would absolutely be appropriate, Your Honor. I absolutely do think it would be appropriate. Whether, there may be cases that were tried in the interim, and I don't know how they would play out, but going forward, yes, it's absolutely appropriate to have a qualified examiner, view the history, the sexual history, which is the way we predict the future sexual, the likely future sexual offenses, and say whether or not this is going to meet the standard that the court has set in Suave. I mean, this is going to be a small class of people, I think, where the offense, the nature of the offenses is so intrusive, even though there's no contact, that we nonetheless think that they're sexually dangerous. I don't think this is a big class of people, but nonetheless, there are some cases.
Now, do you agree that with regard to the admission of the police report concerning the case in which there was a charge of rape for which he was found not guilty, do you agree that there was error in not redacting that part of the police report which spoke of penetration?
Let me say two things. This was not tried in front of a jury, Your Honor. So
Right, to a judge.
It's
Right.
jury waived. It's
Right.
jury waived.
So it wouldn't keep it from the judge in practice, but of course, we
Right.
expect judges
But
to be able
more than
to.
that, I think that Judge Roop, if you look at her opinion, you'll see, she does not
Right.
rely on the fact of penetration.
But she mentioned it in the facts, but then
she-
she did not mention it later on.
Does not mention it in her findings. She does not rely on it in her findings. I think that she could rely on, I think if you look, there were 4 counts in that case. She was actually the trial judge in that case, so she had presided. The open and gross lewdness finding of guilty occurred on November 3rd, and the allegations of oral sex and dissemination of material that was harmful to a minor, those also occurred on November 3rd. And I think that what she did was say, because the jury still found open and gross lewdness on November 3rd, it's appropriate to look at some of the attendant circumstances, in connection with that offense. Why would we find shock and alarm here? It's partly because of other things that the child said happened, including being backed into a corner right before Mr. Fay exposed himself.
And that's all in, just the police report was put in, nothing else?
Yes, there's no witness. There was no live witness, if that's the question.
And it wasn't that Judge Roop was relying on her memory of the
I
trial?
don't know. There's nothing to suggest she was relying on her memory, although she was the trial judge and she also presided over several probation revocation hearings on Mr. Fay. I think that when the court decided Suave and established the standard in Suave, that the court was looking, and I watched the oral argument in Suave in preparation for today, and I think what the court was looking for in establishing this heightened standard in Suave was to establish a standard that would meet the requirements of due process, of substantive due process. And this is it's a difficult area. There is not a lot of guidance, it seems to me, on what constitutes dangerousness. We've quoted the Torsky case from Illinois to say that the Supreme Court has left, state legislatures really with a fair amount of discretion in defining what's dangerous. And I think it's clear, the shock and I think it's appropriate to say that shock and alarm is not sufficient to have somebody be found dangerous. There has to be more than that.
So the trouble with that is that, you keep coming, the legislature said that was one of the predicate, that open and gross was one of the predicate offenses. And yet there's an argument, at least, that Suave basically said, but that's not enough. Continuing open and gross conduct is not enough to establish dangerousness, because you have to have not just shock and alarm, you have to have something more.
Correct, Your Honor. But I think that Suave also said, and I think that's what Judge Roop relied on. Suave also said, we're not saying that a non-contact sexual offense can never be can never be a basis for a finding of sexual dangerousness. And I don't think that as a matter of substantive due process, there's a requirement of physical violence or physical injury. If you look at some of these cases, some of the cases that the Commonwealth has cited, they are not, they're not all acquittee by reason of insanity cases. They also are cases where the state courts are struggling with how do we define dangerousness for purposes of what would be a Chapter 123A commitment proceeding in Chapter 123 commitment in Massachusetts. When is somebody dangerous to him or herself or to others? And the standard is not violence or contact. It can be a measure of, I believe, psychological harm, psychological damage.
Well, we certainly didn't close the door on that. We said in that case, of course, there was no evidence, no reason to believe that that person's conduct would escalate into contact offenses, and no evidence that he stalked, lured, approached, touched a victim, or that children were involved. Clearly, sort of setting that aside as perhaps circumstances where just because it's a non-contact offense doesn't mean it's not a menacing offense.
Right, and if I just very briefly, I know my time is up, but there are just two other points, and that is that there are states other than Massachusetts that at least their statutes provide for the possibility that a non-contact offense directed at a child can be a basis for finding of sexual dangerousness. We would not be alone. The state
You
would
have
not-
them in your brief?
I do. They're in footnote 13, Your Honor. They're hard to sort through, but they're there in footnote 13. And then I would say again, I would point again to the fact that the United States Supreme Court in a variety of contexts has acknowledged that protecting children from exposure to sexually explicit material, to sexually explicit activity, is a compelling government interest. Thank you very much.
Thank you, counsel. We'll take our morning recess now.